Start with agenda item 8A1, which is case HR 24-049. We'd like to hear from Mr. Cartel first. I would also, for the gentleman who is manipulating the TV screen in the room here, one thing I would ask is that most of the material that you have provided, and we appreciate that you've taken the effort to bring a TV in here, has been included in our board packet already. So we would just ask that anything you're going to share is above and beyond what is in the board packet, because the board has had a chance to review all that material, given we have a lot of cases. So, all right, with that, Mr. Cartel, if you would please give a brief synopsis of the complaint.
Good morning. So on April 8th of 2024, the board received a complaint alleging that respondent consistently uses misrepresentation, fear-mongering, concealment of material facts, deceit, cyberbullying of individuals, and shock value as a method to convince new home buyers they need his services. It is also alleged that respondent publicly refers to female professionals in derogatory sexualized terms in violation of ASHI standards, requiring that home inspectors conduct their services with professionalism and integrity toward the public. It is further alleged respondent accepts equipment he uses in his business that he would otherwise be required to pay for in exchange for endorsing its use to his clients and the public. It is additionally alleged that respondent intentionally tags his videos in a manner that reaches a national audience. So I wanted to clarify a couple of things regarding what the investigation did not cover due to the limited jurisdiction of this board. This investigation did not address the responsibilities of the home builder, being that this board does not have jurisdiction over home builders. That would fall under the jurisdiction of the Arizona Register of Contractors. Secondly, this investigation did not address any civil liabilities, such as slander or libel, being that this board does not have jurisdiction over civil matters, which would fall under a jurisdiction of a civil court. During this investigation, we conducted interviews, reviewed many of the videos that are available for watching, and reviewed documents. At the conclusion of the investigation, we were unable to find any verifiable violations of the Board's Practice Act. And I can go into more detail if there's questions as well.
Thank you, Mr. Cartel. We do have Ms. Jennifer Mullen, who is the alleger, and we also have the respondent, Mr. Porter, here in person, who wishes to listen and is available for questions unless that has changed since this information was provided to me. So with that, Ms. Mullen, we usually provide 3 minutes for alleger and respondent to address the board. So if you'd please state your name and then go ahead and proceed.
It's going to be hard for me to remember to press the microphone continuously. Before I start my 3 minutes, I did prepare a video that cuts everything down to about 2 minutes and 33 seconds. I did forward it to the board on Thursday. I don't know what's in your board packet, so I don't know if it's a repeat and if I should play it.
We do have that video, and I believe all board members have reviewed it. So it would save you some time, and you can just speak regarding your position on the case if you like.
I'm happy to do that. I won't need you to play the video, I guess. So my name is Jennifer Mullen, and I represent Taylor Morrison in this case. They are the one who brought this complaint. The primary reason they brought the complaint is their belief that what Mr. Porter is posting on social media does violate the Arizona Administrative Code, Chapter 30, 301, Paren 2, which says specifically, a registrant shall not engage in fraud, deceit, misrepresentation, or concealment of material facts. If you watch through the video, there were 5 slides that I placed in there because I knew I wouldn't be able to use PowerPoint. And each of those slides goes through the specific, just a few days worth of video, goes through the specific things that he has done that are inappropriate. He has stated that Taylor Morrison will not allow third-party inspections prior to close. That is 100% not true. He knows it's not true. I informed him of that which is where he decided to start calling me Debbie from legal and making references to Debbie Does Dallas. My client is here today because this is not professional. You are a board of professionals, and I cannot imagine that anyone thinks that this is appropriate. It is a blatant misrepresentation of what Taylor Morrison does. His videos are nothing more than advertising. His license allows him to do inspections on private homes, turn over the inspection report to the homeowner, and walk away. But what he's doing is using the license that this board granted, and even just sitting here for 10 minutes, I'm so impressed with the care and integrity that you serve with. It's unbelievable to me that this is okay. It is conduct that is violative of Arizona law. It's not appropriate for dismissal. And I think it's worth saying that if you dismiss it, he's already said what he's going to do with the dismissal and what he's going to do to Taylor Morrison as a result of that. I understand no one wants to be involved in this. Taylor Morrison doesn't want to be involved in this. Taylor Morrison is a home builder. They want to build homes. I don't want to be involved in this. And I am personally being attacked, although not by name until today when I had to stand here and reveal that to you. I need you to step up. You're on this board because the Arizona government trusts you to make decisions relating to licensing this profession. Your job is to license and enforce. I need you to enforce. Taylor Morrison needs you to enforce. This is your opportunity to do it. I'm sure you're all aware that the law changes as of September 14th. This is your opportunity to say, you know what, we're not going to let our people do this. I don't want an architect to make a commercial and put it on TV that says, oh my gosh, don't go to this engineer. He's got hairy nose hairs. This is your chance to do something about it. And so Taylor Morrison is asking that you control this kind of advertising, that you suspend his license until he has taken appropriate professional ethics training so that he has a much better understanding of what it means to be in this profession. Thank you.
Thank you, Ms. Mullen. Mr. Donald, I'd like your, it's not legal advice, but I would like for you to maybe help clarify the difference between the Practice Act and what the alleger was referencing, which is the administrative code, if that's possible.
Well, I think, Mr. Chair, that perhaps what you may be referencing would be the difference between the regulatory board and the civil forum. This may be a matter that will be more appropriately dealt with in a civil forum, but may not be a matter for regulation under the board's statutes and rules. Unfortunately, the board only is a regulatory board. But again, this does not preclude any action by any party in any other forum.
Thank you, Mr. Donald. Board members, anyone have any questions for the alleger, or we do have the respondent here to answer questions as well?
Mr.
Smith,
Chair,
please.
yeah, I've got a question. Mr. Cartel, why wasn't the, when you wrote up this report, it doesn't state anything, and I believe Ms. Mullen put in here code of ethics or relating to R43301. Was that addressed at all in your investigation?
Yes, sir. So the code of ethics that's mentioned was the ASHI standards. We don't enforce ASHI standards beyond the minimum standards that are based on the actual practice of a home inspection. At the beginning of the investigation, the alleger had confirmed that the complaint is not about any particular home inspection or the contents of the home inspection, but purely based on the social media content. Now, as far as the code of conduct in regards to misrepresentation or fraud or falsehood, I did review the videos that was provided to us by alleger, plus many more that are available on social media. And although many of his videos have content that it could be argued that they have implications or inferences can be made about Taylor Morrison, which may or may not be true, I was unable to find any direct verifiable falsehoods in that. The issue with the indication that Taylor Morrison does not allow home inspections prior to the home closing. There is some more information behind that I was able to uncover. In the video, respondent states that he was not allowed to do an inspection before the close date. The background to that is that they do have a policy that you can do an inspection or third-party inspection beforehand, as long as I believe it's 15 days before closing, and there's a couple of other restrictions as well, that the 15 days being the biggest one. In this particular incident, respondent was reportedly given permission by the local office to do one within that 15 days. But when he had arrived, the corporate office had stepped in and disallowed it, and so he wasn't allowed to do that particular inspection. I did confirm that with the homeowner. I tried to reach out to the local superintendent that allegedly gave the permission, but he declined to make a statement. So there is some information behind that particular video. Needless to say, the video didn't give all the details, but being that there's more information behind it, I was unable to confirm and verified lie. If there's any other questions about any more particular issues, I can definitely address those as well.
Well, when I looked at this, I saw the whole argument here was relating to R4303012, and in your synopsis, you're calling it something totally different, like board, what's it called? Board protocol or board?
Talking about the practice?
Yeah,
Act?
board practice.
Board practice
So
act.
I don't know if that really relates to the complaint filed here. I think the complaint was R4303012. And I believe the alleger has presented a very strong case here. And I think there's some concern here for misconduct.
So when I mentioned the Board's Practice Act, the Board's Practice Act refers to the culmination of the statutes that relate to the board, as well as the minimum standards and the administrative code that are specific to the board. So that was a reference there. I must confess, I don't have R4303012 memorized, and I don't have it in front of me. So if someone could remind me which one that is, it would definitely help.
Go ahead, Judith.
Certainly. R430-301-2 reads, a registrant shall not engage in fraud, deceit, misrepresentation, or concealment of material facts in advertising, soliciting, or providing professional services to members of the public.
Thank you, sir. So I did address that in that while an argument can be made that there are implications and inferences that can distinctly be made from his videos, I did not find any statements that were verified, that could be verified as a direct outright lie. So although many things can be implied or inferred from that, I just wasn't able to verify anything that was direct.
I think, Mr. Carthel, it didn't rise to the level that would be needed for that to be impacted by this board, if I'm paraphrasing what you're saying.
Correct. I suppose that would be up to the board to determine, but yes.
Thank you. Any other questions or comments from the board? Mr. Smith?
I think this is a pretty big issue, and I think the board should take it seriously and talk about this because we are professionals and we need to treat people as professionals. And I've spent 2 hours looking at these videos, and I was kind of appalled at it, to be honest with you. Doing this kind of a treatment to a new home builder is going to cause hardship for other home inspectors because they're going to make it almost impossible for us to do inspections. They're going to raise the insurance, I'm sure. They're going to make it so hard to do. So I really think we need to talk about professional conduct here.
Mr. Chairman?
Yes, Dr. Campbell.
Oh, thank you. Yes, this is Dr. Campbell. I think it's important for everyone on both sides to fully understand the board's mandate to protect the public interest and safety, maintain the integrity of the professions, and ensure that licensed professionals act in a manner consistent with the standards of our field. Oftentimes, in all fields, conflicts will arise. And it's up to us as professionals to make sure that we stay behind the line that crosses those professional mandates of conduct. And so people need to keep that in mind, because if these things continue, they eventually turn into situations that do come back before the board. And once you cross the line into violating one of the board's official rules of conduct, things can get very bad for a licensee, and we don't want to see that happen. And so I think people need to take a deep breath, communicate better, start from a place of mutual respect, and behave as you would want others to behave towards you. Thank you.
So, Dr. Campbell, if I can ask you one follow-up question, then your position then relative to this staff recommendation for dismissal is, what would your position be on that? And
In my experience on other boards, we have essentially issued non-disciplinary letters requiring kind of admonishment of ill-spirited behavior by licensees if, in fact, we believe that that conduct goes outside of our standards. And so when that occurs, we can issue warnings if we feel the situation is deserving of such. And then that creates a documentation in the file for if any future conduct comes before the board. And I'm not sure if this board allows for things of that nature or not. But the health fields do.
Mr. Chair, if I may, just to remind members of the board that they do always have the option of what I believe Dr. Campbell is referencing would be a non-disciplinary letter of concern.
I'd like to make a comment if I can. Is
yes,
Stacey
Ms. Campbell,
Skanke?
please. Yes.
Yeah, so I didn't feel that this rose to a violation. And I feel like we need to stay in our lane of our kind of very limited jurisdiction of what is appropriate before this board. And it's been mentioned, it's possible that this might be better suited in a civil context. And so I definitely don't think there was anything for our board to take action on. And I just wanted to caution kind of any, I know there's, different preferences of what the advertising is and how he goes about communicating his information. But I would just be very weary of going outside of our lane, and keep in mind in Arizona, we have very, very broad free speech protections, even broader than the US Constitution. And I don't want to be in a position where we're regulating the speech other than our very limited directive of fraud, et cetera. So just with that, I would be in support of dismissal.
Ms. Skanke, I mean, that is an option that right now we have kind of two different positions that some board members are articulating. And the one way we can address that is we could do a motion to dismiss. If that motion passes, then that's it. If it fails, then we could look at Mr. Smith or Dr. Campbell's potential of a letter of concern, or I could do it the other way around. We could do a motion to issue a letter of concern first, and if that fails, we could do the motion to dismiss.
And Mr. Chairman, I would also consider maybe a course or something on professional conduct or our code of ethics. Maybe a review of that.
And Mr. Chair, the only way the board could do that would be to impose discipline. That would have to be a probationary matter.
May I address the board and answer a couple of the questions that have been raised?
Yes. If
I
you
promise to be
briefly,
brief.
thank you.
Should I do that now?
Yes, go ahead, Ms. Mullen.
So first of all, in response to Mr. Donald's comment that you are a regulatory board and this might be better served for a civil forum, That's not true. There's no relief for Taylor Morrison other than monetary damages. What you and only you as a board can do is impose sanctions on his license in some manner, like has been discussed by Mr. Smith. The other thing I wanted to address was the free speech concern. This is not a matter of free speech. There is case law that I'm more than happy to cite that affirms the ability of the state to regulate speech when it violates rules of professional conduct. And in the way that Mr. Porter operates his social media accounts, he's using his credibility comes from his license. His credibility isn't because he's just a regular citizen. And that license does allow you as a board and the state of Arizona to promulgate rules that limit free speech, because in fact that speech is actually conduct, not considered speech.
Thank you, Ms. Mullen. Any other comments from the board?
Sure, I have a question for Ms. Mullen. Would you be here if those videos had not included Taylor Morrison in the background or represented Taylor Morrison?
Taylor Morrison is my client. I made the complaint on behalf of my client, and the investigator asked me about that. I personally would not have been willing to take the personal safety risk to make this complaint if it was only calling me a.
Mr. Chairman, Ms. Scott Sales, Mr. Cartel, on the looking at some of the documents on here and the videos and stuff that were online, just want to confirm from what I see, it appears that the home inspector tagline is included in a number of the documents online. Would that be, from what you've seen, correct?
I apologize. I might be showing my age and my ignorance, but I'm not sure what a tagline is.
Oh, just like a bio or anything like that in there. So if someone were to look at a video, they click down through, they might see that so-and-so, in this case, Mr. Porter was a home inspector.
Yes, sir. His profession was mentioned in a number of them.
Okay. I guess, Mr. Chairman, looking at, I saw a lot of the video, oh, I saw all the videos, and one of the videos in there was related to the gas bubbles and such. And it appeared there was a voiceover, and I think then it was later explained, I think in the documents were provided on Friday, that there was like a voiceover. So it sounded like someone was talking right then and there, but apparently it was some text, or not text, some voice that was spliced from a different video put in on top of the gas that made it appear like someone was saying that this wasn't a big deal or something of that nature. So that's the biggest sticking point I'm having with the code of conduct and ethics and the other items are there. Was that truthful in that this other person wasn't there saying these words? They're saying it related to, I believe, related to stucco,
a little bit of laugh
instead of
showing on
gas.
stucco.
And then it exploded, the appearance of an explosion at the end. So and those are just my thoughts. So I'm just listening to all the information here, and if there's any other questions, it'd be good for folks to bring them up now with the videos and anything else there. There's a lot of information in there, and there's a lot of stuff to digest for sure.
Mr. Chair, can we ask Mr. Porter to come up? I do have some questions.
Mr. Porter, would you mind coming up? You can sit right over there. Just state your name, and this board will ask you some questions, or at least one. Go ahead, Mr. Smith. Well, actually, first, if you just state your name for the record.
My name's Cy Porter.
Thank you. Mr. Smith.
Mr. Porter, are you a registered, are you with the ROC? Do you have a license with the ROC also?
Just the BTR.
It's the BTR. Okay. Your reference in your report, I looked it over, there's a lot of ROC standards that you put in there, so I was kind of curious about that.
What questions do you have about that?
Well, it just seems like, it almost seemed like an ROC inspection. That was my thing. And I understand the inspection report was not evaluated. So I just wanted to get that information.
The state standards are included in some of the findings to support the findings, because a lot of billers try to say those are not issues when they actually are.
Okay. Let's start out with that third party agreement where you were stating that you were denied access. it's typical with all new home builders. It's a DocuSign and you've got to do it at least 10 days prior. Did you fill out the DocuSign agreement?
So it's actually not typical. I am given about a DocuSign maybe once every 4 months. The DocuSign for the Taylor Morrison inspection, I don't even recall if there was one for that specific home, but what happened was someone said, hey, look, the DocuSign says this, but you guys agreed to this inspection during this period. What are we going to do? And they said, that's fine. You can still come. Once they changed their mind to prevent this issue in the future, we've just decided not to do inspections for that builder until they can come to a different agreement for the buyer and the home inspection process.
So when you do your new home inspections, you never have to do a DocuSign for all the builders that you worked with?
90% of the time, no.
How about insurance? Do you have to have insurance?
When I'm required to sign those DocuSigns, some of them, not all of them, will ask about insurance.
Wow. Okay.
Also, just to make it clear, 99% of my inspections are done after close and actually not done before close. So these are actually very rare circumstances that I do inspections before close.
Oh, okay. So the homeowner owns the property at that point.
99% of the time. So most of those videos are after close.
Okay. Looking through your report, there's a lot of items that you point out that is very common on new construction. Do you agree?
Yes.
Okay. And are you familiar with the code of conduct, the R430, whatever it is? R430 301. Are you familiar with what we've been discussing?
I have been listening and I have read it. Yes.
Do you feel you violated any of those?
I think that is for someone who has authority to determine, because I believe I do not.
Okay.
Thank you, Mr. Smith. Board, other questions for the respondent since Mr. Porter's here? If not, Mr. Smith, you had expressed an interest, and I believe Dr. Campbell was aligned with that you would be interested in potentially making a motion for a letter of concern.
I'll let Mr. I personally think there should be some additional training on a review of professional conduct. And if we can't do that with just a letter of concern, I'd like to bump it up one then.
I believe then the next step up would be a letter of reprimand, which would then, Mr. Donald, provide the opportunity to add any type of continuing education or other methodology.
Yes, any finding of a violation, should the board find that there's been a violation of board statutes and rules, the board would then have the option to impose discipline, and discipline would be anything from the board's disciplinary toolbox, ranging from a letter of reprimand up through revocation. And as soon as you begin to get into discipline, you have the option to have probation, and probation would be able to include terms that are reasonably designed to ensure that the person is rehabilitated from the violation.
So, Mr. Smith, since you had originally brought this up, would you like to make a motion to that effect?
I'll make a motion that
And please make sure you're quoting the statute section as well when you do that. The R30, I know.
Yeah, we would be able to, you would have to be able to enunciate the violation on the record.
All right, I'd like to make a motion that letter of reprimand be placed regarding R4 30-301-2. And I'd like to recommend additional training in professional conduct.
What was the conduct underlying?
The fraud, deceit. Is that what you're asking?
The conduct that you believe constitutes a violation of that?
All right, so if the entire presentation that Jennifer Mullen put together had all these videos and comments. I could attribute it to all that.
Okay, so you're saying that the videos posted contained statements that would constitute violations of R430, 301, 2 through engaging in fraud, deceit, misrepresentation, or concealment of material facts in advertising, soliciting, or providing professional services to members of the public. Would that be an accurate statement?
That would be, thank you.
Certainly.
So if that's your motion, do we have a second?
Do we need to state the case also?
No, for the seconding the motion, simply seconding would suffice.
Oh, yeah, Mr. Smith, if you could just quote the agenda item or the case number as part of your motion. Good call, Dana.
Okay, the agenda item is 8A1.
Thank you, Mr. Smith. We have a motion. Do we have a second? Keep in mind, we can't vote on an item if there isn't a second.
It would die for lack of a second, were there to be no second.
Correct. I'll go ahead and second to allow the vote to go forward. I would like it to be a roll call vote, though. So, Julie, if you wouldn't mind just doing that. And if that vote were to fail, then we'll go with the original motion of dismissal.
Ms. Bohal,
Nay.
Dr. Campbell,
Nay.
Mr. Gilmore,
Just a comment. I'm going to vote nay, but I am sympathetic to Mr. Smith and his concern about this gentleman. Even though we haven't been able to find any specific violations of conduct, I think we are here to protect the general public. And I think some of the allegations being made in some of your videos are not good for the industry and our ability to protect the general public. So I'm going to vote no for this, but hope we can come back with a letter of concern.
Ms. Klett,
Nay.
Mr. Kaleka,
Nay, but I will echo what Mr. Gilmore said.
Mr. Lindsay,
I'm going to vote no, but I also wanted to say that I know Ms. Mullen, I've worked with her in the past, but I don't feel like that impacts my ability to vote on this case. Just wanted to get that for the record.
Mr. Nesgood,
Nay.
Mr. Sales,
Nay, but for similar reasons, maybe something a little bit less than this.
Ms. Skanke,
I'd be voting nay. I just wanted to reiterate my point of, we're saying that we can't find specific violations of conduct, and yet we're fishing for some kind of something to hang our hat on. Just because we don't prefer his advertising methods, I don't think that rises to any disciplinary action, even a letter of concern, which I know is non-disciplinary.
Mr. Smith,
Aye.
the motion fails.
Thank you, Julie. All right. Since that motion failed, we will entertain either another motion, whether it's a motion for dismissal or a motion to issue a letter of concern.
This is Stacy Skanke. I will make a motion for dismissal.
Thank you, Ms. Skanke. Do we have a second?
Haley Bohal, second that.
All right. We have a motion and a second. Any discussion? All right. Hearing none, all those, let's go ahead and do another roll call, Julie, if you don't mind.
Ms. Bohal,
Yes.
Dr. Campbell,
Nay.
Mr. Gilmore,
Nay.
Ms. Klett,
Nay.
Mr. Kaleka,
Aye.
Mr. Lindsay,
Nay.
Mr. Nesgood,
Nay.
Mr. Sales,
Nay.
I'm sorry, I didn't hear that.
Nay.
Ms. Skanke,
Aye.
Mr. Smith,
Nay.
motion fails.
Thank you, Julie. So since the motion to dismiss failed, we continue to entertain motions that would pass. So with that, I believe there was a discussion about a motion to issue a letter of concern. Again, if the board member wishes to do that, please specify why, and if you wish to just reiterate what Mr. Smith had said, but at a lesser severity, issuing the letter of concern, please state as such.
Chair, this is Jack Gilmore. I'd like to make a motion that we issue a letter of concern regarding some of the advertising practice of Mr. Porter, and to be concerned about his presentation to the general public on his critiques of some of the home builders without appropriate inspection reports and documentation. It seems like there's a lot of innuendos and allegations in there without any proof. So I think it's just a letter of concern that to be more cognizant of the detailed information that he shares with the general public, and be concerned about his reputation of some of the home builders. And there might be some more to that, but I'll let some of the other board members add additional concerns if they have any.
Thank you, Mr. Gilmore. We have a motion. Do we have a second?
Dr. Campbell will second.
Thank you, Dr. Campbell. Any final discussion?
Mr. Chairman, this is Scott Sales. I'm just going back because I'll just related to R430 301 2. To me, I'm stuck on the item for misrepresentation or concealment of material facts in advertising, soliciting, or providing professional services. I'm really stuck on the gas meter item with the voiceover from that wasn't at that location when the gas was tested. That's my that's really everything came down to just that. That's the only thing I, in my opinion, have an issue with on this whole thing, was that one voiceover of someone else saying something about, that's, I can't remember the exact words on it, but that stuck with me just because it's gas and helping protect the health, safety, and welfare of the public when that person wasn't there. If someone was there, I mean, we don't know what they would or wouldn't have said in that instance to say, well, wait, we're going to get that fixed right away, or something of that nature, or we don't know the severity of the gas leak and everything. It's definitely a serious item, but the voiceover to me was the one sticking point of why I'm going with this this level of concern. Yeah.
Thank you, Mr. Sales. Any final comments by the board? All right, we have a motion. We have a second. Julie, one more time, if you would, please.
Ms. Bohal,
Yes.
Dr. Campbell,
Aye.
Mr. Gilmore,
Aye.
Ms. Klett,
Aye.
Mr. Kaleka,
Aye.
Mr. Lindsay,
Aye.
Mr. Nesgood,
Aye.
Mr. Sales,
Aye.
Ms. Genke,
Nay.
Mr. Smith.
Aye.
Motion passes.
Thank you, Julie. All right.
Mr. Chairman, if we could just, since it's been a little while, could we have maybe Mr. Donald be able to explain a little bit more about what the level of letter of concern level means, and disciplinary, not disciplinary portion of it?
Certainly. A letter of concern is generally issued when the board has concerns that behavior does not necessarily rise to the level of violation of board statutes and rules, but that continued behavior could lead to a violation of board statutes or rules in the future. And so effectively, it is putting a person on notice that this kind of behavior could lead to problems. We have concerns about it. It doesn't quite rise to the level of violation. There is no discipline involved. But again, moving forward in the future, continued actions like the one that you've expressed a concern about, Mr. Sales, could certainly, under different circumstances, constitute a violation of board statutes and rules.
Thank you, Mr. Donald. Thank you all for coming today. We appreciate your time.